Good evening. I'll call the meeting to order for the Sebastian City Planning and Zoning Commission, Thursday, July 21st, 6 p.m. And our first order on the agenda is Pledge of Allegiance. Please stand. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Could we have roll call, please, for attendance?
Mr. Roth?
Here.
Mr. Dodd has not arrived yet. Mr. Kizilbosh?
Here.
Ms. Cottenberg? Here. Mr. Carter?
Present.
Mr. Alvarez?
Here.
Thank you. In the form of announcements for tonight, Mr. McManus, Mr. Reyes, and Mr. Hugan are excused for tonight's meeting, and Mr. Al Alvarez will be voting tonight.
Mr. Chairman,
Yes.
Ms. Simchick also asked for an excused absence tonight.
Okay, thank you. We'll make note of that. We have no minutes to approve tonight. They are being caught up. The first item on our agenda is a public hearing, and it's a public hearing on our sign ordinance, which is some changes being proposed to that on ordinance 0-16-05. What I would like to do is have our city attorney, who has done one incredible job on looking through this ordinance to make sure it conforms as we know best it can with the Supreme Court ruling, and to keep the city of Sebastian in good stead with everyone. I'd like to have the city attorney make his presentation on the ordinance as he sees. I don't think there are any other changes that we need to make note of at this point, except that there will be an opportunity for public input and questions by the commissioners of the staff and the city attorney. So, Attorney Ginsburg, if I could have you review the changes and your comments on those.
Let me start by saying that tonight you're really convening as the local planning agency for purposes of reviewing a proposed ordinance and making a recommendation to the City Council with respect to it. Let me go ahead and read the ordinance title so that we can initiate the public hearing. Ordinance 0-1605 is an ordinance of the City of Sebastian, Indian River County, Florida, relating to signs, repealing Section 54-3-16.1 of Article 16 of the Land Development Code, and enacting a new Section 54-3-16.1, providing the purpose, intent, and scope of the sign regulations, amending Section 54-3-16.3 relating to exempt signs, amending Section 54-3-16.5 relating to permitted signs, amending Section 54-5-22.2 of Article 22 of the Land Development Code relating to definitions, enacting Section 54-3-16.9 relating to substitution and severability, providing for conflict, codification, and an effective date. Let me introduce the topic before you ask for public input by saying that, and just briefly, we used to think as government lawyers that we could regulate signs legally under the First Amendment as long as we weren't concerned, we were what they call content neutral. We were neutral with respect to what was said on the sign. And as long as we were, as long as we didn't take sides, as long as we didn't show preferences for certain wordings or positions or over others, we were okay. That changed last year with the Supreme Court's opinion in the case that caused me to make these suggested changes. Now the court says, in addition to being content neutral, we also aren't permitted to read a sign in order to classify that sign and provide specific regulation with respect to that class of signs. If we had to read the sign in order to classify it, then we had to meet such a high standard of judicial review that we couldn't meet. Local government as a whole can't meet the strict scrutiny standard, and that's the highest level of standard that the courts apply to legislation. And when you reach that level of scrutiny, we can't prevail in a court. So that was the dilemma. We now have to provide regulation for signs that doesn't rely on what the sign says. It's not the easiest task in the world, and I was hoping that by this time, and we're talking about a year down the road, I was hoping there would be a model ordinance, and there are several organizations that might have provided one, but other lawyers have had all kinds of trouble with this, just like I have, and at the moment we don't have a model ordinance. Now I am going to a seminar at the end of next week. Maybe there'll be one there. This is a topic of discussion, and it's been a current one over the past year. So it's possible that there'll be something else. Some of what is provided here has been taken from ordinances enacted by municipalities elsewhere in the state within the last year. Some of it is my own writing that I've never seen duplicated anywhere. And I've tried to put together a very basic document that we can use that meets some of the court's strictest or gives us the most trouble legally, and I've tried to frame it in a way that will allow us to go further. This is my first pass. I think there will be other ordinances that follow this one. I haven't prepared them, just so you know, but I believe there will be. This is my first pass at this. And I think I've addressed the three most concerning issues.
You're saying other passes on this relative to perhaps other sections
Yes,
that weren't
other sections
addressed
of
right
the
now?
code.
Okay.
Yes. I've dealt, as I indicated in my memo to you, I've dealt with the three specific areas that I think are most susceptible to challenge under the court's ruling. And those are special event signs, political signs, and civic event signs. What I would like to do at this point, with your permission, well, I could do one of two things. We could go further, and I can get into a little more detail, or we can have the public hearing, and then during your discussion, I can go into further detail. What would you like to do with regard to that?
I think perhaps it would be best to hear your input
Okay.
For the benefit of myself and the other commissioners and the public, so that we have a better understanding. It might eliminate some questions,
Okay.
if you don't mind doing it that way.
No? First, I want to thank you all for coming. This is the only thing on the agenda, and that wasn't my intention. I mean, I was hoping that there'd be other things, applications that you could deal with as you ordinarily do. Turns out this is the only thing, and thank you for coming for it, and I appreciate that. The first thing I did was provide a very extensive section on purpose, intent, and scope of the regulations. Ordinarily, this is provided for in a sentence or 2 or 3 sentences. In fact, there was a short paragraph here which I repealed in its entirety, and I replaced it with, 3 or 4 pages? The reason for that is the courts will give credence to legislative intent and purpose, and if you spell it out with enough detail, it may help sustain a regulatory provision. And so a lot of thought was put into these first few pages, introducing the sign ordinance. Let me skip to the end, because I think it makes for a better, this frames the discussion. At the end, what you'll see on starting on page 8, the substitution of non-commercial speech and so forth, and through the end of the ordinance. Those are new sections that I'm going to put in the code. Substitution is an important one. It provides for some flexibility, which the courts like to see with regard to signs, and is especially important since we're not regulating what signs say. Severability is extensively discussed. Usually that provision is a standard provision in every ordinance, but doesn't go into the code of ordinances. In this case, it's going to go into the code because it's important. I don't want it to get lost. And that also are basically instructions to the court or advice to the court from the City Council as to what they really mean when they're enacting these provisions, knowing that they're doing so in the context of First Amendment, and that there are a great many issues, First Amendment issues, with respect to the legality of the regulations in this field. And so these are detailed, I don't want to say instructions exactly, but provide the court with a detailed view of the City Council with respect to how the court should interpret our sign code if they find that a particular sentence or section, word, paragraph, section, whatever, is unconstitutional. And courts often appreciate that kind of information, so we should be able to retain the rest of our sign code intact using this kind of language.
So in this substitution,
Yeah, substitution, yes.
yeah, owner has a more leeway. He could put any kind of speech, right?
Right,
Okay.
right, because if we're not reading a sign, then we wouldn't know or care what it says. Now, there are certain outer limits to that, like, profanity or something like that, pornography, that's beyond
Yeah,
the
beyond
protection
the
of First Amendment. But Eat at Joe's and Vote for Joe can be on the same sign. Anyway, so those two sections of what you have in front of you, the extensive purposes clause at the front end and the extensive substitution and severability clause at the back end, frame the substantive portion of the ordinance. I had to change, as you'll note, a number of the definitions in our sign code, because if you read the part I took out, and these are on page 7 and 8, if you read the parts I took out of the various paragraphs, you'll see that they actually refer to what a sign says. It identifies a business, or it talks about something that's so forth. That had to be replaced with more neutral language. And all of this is original, by the way. As far as I know, there's no other community that's done this, although why, I'm not sure. I looked at a number of sign codes adopted after the Reed decision, and I still find them based on reading the signs. And I don't see how that can survive. But I've identified or defined abandoned signs in a way that doesn't deal with reading it.
Can I
Same-
ask a question about that abandoned sign?
Sure.
Is there any requirement to contact the owner of an abandoned sign? If the business is closed and the property ownership is in question, do we have any real strong liability to contact the owner before it's removed to say, is it abandoned? Or are the restrictions you've placed here strong enough that we can make that determination and it's enforceable?
I think if this is our definition of an abandoned sign, I think we can remove it.
Okay,
But I think the way Sebastian works is we almost always contact the person. Just the way our code enforcement officers, yes, they can cite you first time out, usually, almost always. They talk to the person, show them the ordinance, explain what the violation is, give them a few days to correct it, and that way the person can correct the problem without getting a citation. And I think that's typically what we would want. In a situation like this, we would want the sign removed. And if they'll remove it, that's great. But if there's an attempt to notify the person, if it's really an abandoned business that's involved, then there may be nobody to identify or nobody to contact.
that's true, and that's why I brought it up, because I thought an abandoned sign could linger on, and I'm glad you said the way this is written,
We could pick it up.
gives the authority.
Yes.
Yeah.
And there are other sections of the code which I didn't touch, which involve us picking up signs that aren't provided for in the code. So we can do it. One issue that was a very difficult one for me legally was the issue of political signs. And that is, let me put it this way, you'll note that, did any of you get a chance, if you actually got through the material, the last couple pages are the University of North Carolina's brief analysis of the decision and how it applies in the context of regulating signs under the First Amendment. I agree with most of what's said there. But what he said about political signs, I don't think is entirely accurate. And the reason is this. There are a number of court cases, not at the Supreme Court level, but circuit courts of appeal, federal appellate level, that require governments to respect political signs more than treating them just like any other temporary sign. I mean, a political sign is one category of temporary sign. And under the Supreme Court's ruling, you've got to treat them all the same. It doesn't make sense under our code or anybody else's code to treat political signs that way. There are a number of federal court cases that say, for example, that struck down provisions saying political signs can only be allowed 60 days before an election. Several court cases have stricken that 60-day provision down. Our code provides for 75 days. And that's what I put in the definition of political sign, 75 days. And the reason for that I picked 75 days is that goes to the first day of qualifying. So if you qualify for office, you ought to be able to tell somebody about it. And I think a court would respect that dividing line. That changes you from an ordinary citizen to a candidate, you know, once you qualify for office, and that's the first day you can qualify. So,
Mr. Ginsburg.
yes.
On the 60 days that you mentioned,
Yeah.
it's been struck down, what is, I mean,
Mr. Carter, could you turn on your mic, please?
it is on. Sorry, it wasn't. I'm curious as to why, you mentioned 60 days has been struck down.
Yes.
And why was it struck down instead of, and now we're going to 75, why wouldn't that be struck down as well?
It might be, but I've never seen one yet that said any number greater than 60 would be unconstitutional. But 60 was used as kind of like a rule of thumb, as a common number, and that's been struck down a few times.
And what was the reason or the rationale behind that being struck down?
There are a variety of them. One is that if you're qualified, and say you're running against an incumbent who also qualifies on the first day, that incumbent has serious advantages over you, over his ability to contact the public while you are muzzled. It creates an inequality in the ability of people to contact the public with their platforms or whatever they want to tell the public about their campaign. If you deal with 75 days, it's more equitable since you're dealing with that artificial qualification term, as opposed to leaving an inequality in place. I think that's the main one. There's not the whole point of campaigning, and here's where they start from, is that political speech is viewed by the courts as the highest form of speech under the First Amendment, the most respected, the one where government has the least ability to regulate it. And so you're already starting off way behind the 8 ball with regard to political speech. When I got here 7.5 years ago, the previous city attorney had instructed the staff that the code's 60-day provision, which was there before I got here, couldn't be enforced. And so the city was not enforcing the sign code as a result of his instruction. When I got here, there was a lot of concern about all of that, and I prepared an ordinance going to the 75 days. And that's what the City Council enacted. That's what's in place now. And that's retained in this provision. And I know it's an exception to the general provision that it should be treated like all other, every sign in the same category should be treated the same. But it just can't be. It can't constitutionally be. So rather than have no provision, I retained the 75-day provision for political signs, feeling that that is an upgrade. That is favoring political signs, because temporary signs have a much lesser lifespan. You can't put them up 14 days before the event, got to take them down within 24 hours after the event, kind of a thing. Political and temporary signs can only be done so many times a year, that kind of thing. Those provisions can't apply to political signs. So I'm trying to comply with 2 court orders. The Supreme Court order in the case we're dealing with, the Reed case, and the federal appellate court saying 60 days is not enough. And 60 days, even 60 days, would be multiples of what other temporary signs are permitted under our code. And that's not enough for political signs. So I made an exception for political signs because I think it's constitutionally necessary.
I think you've picked the right balance on it too, because you pointed out the first day that they can qualify, that will fall within the 75 days.
Yes.
And when you look at the calendar where the primary is and the fall election, if someone does qualify, puts their sign up 75 days prior to the primary, they would not need to take it down. If they were successful in the primary, they could leave it up for the fall election without running into any problem.
Right. Right.
So I think, in my mind, I don't see there's any reason that this would not be acceptable.
Well,
Defensible, very good.
Yes. Okay. Now, with regard, and those definitions, like I say, they're all unique to Sebastian, but I think that they do accomplish the end result, which is to, except for the political sign provision, they deal with signs in a way that's effective, can be enforced, and we don't have to read the sign to deal with it. We can deal with it. We can look at a number of other factors and make our decision on that without regard to what a sign says. Now, on the merits of the ordinance, the substantive part, I took out the special event signs. I took out political signs except for the definition, really, and civic event signs. In my mind, those are the most problematic ones, because how do you know something is a civic event sign except by reading it? Or a special event sign except by reading it? There's no special characteristics of those signs that might distinguish them from other potential signs, and so I think that those provisions had to be removed. Now, bear in mind, we have an extensive sign code and 2 overlays as well. All of those provisions, most of those provisions, except for the ones you see here being deleted, they remain. So something that's a civic event sign, even though it's removed from separate regulation under the temporary sign category, it's still a temporary sign, and we still have regulations dealing with temporary signs in our code. And those signs, civic events and special events, are subject to those regulations. And let me generally say this. This is really a procedural effort here. I haven't made anything that's legal now illegal. I haven't taken anything that's illegal now and made it legal. I hope those 2 statements are correct, because that was my intent, not to interfere with the substantive policy decisions that the city has made with regard to a whole variety of signs, but to try and conform our code in a number of ways so that it would be acceptable to the courts under the new Reed theory. And so that's what you have before you. I would appreciate your review of this and comments. It'll come to the City Council again, and if there should be amendments, then I could make them. If you have suggestions, I could make them at that time as proposed amendments. But that was my intent. I hope I gave you enough information for you to review. I didn't give you this time. I think I did talk to you about this once before, or twice before. And at that time, I think I gave you copies of the lawsuit, the case, Reed versus Gilbert. I think I did. So I didn't give it to you a second time. And I also didn't give you the whole sign code. Maybe if I was wrong there, I apologize. I tried to give you the information that might be helpful. Like, I thought that article from the University of North Carolina was a useful exercise in trying to interpret the Supreme Court case. It's a difficult area in the law. There have been a host of lawsuits with regard to all kinds of provisions in sign codes over the years, stretching back 80 years, more. And I think the Supreme Court will be addressing this in the future. And I think my judgment is, over time, they will probably recede to some extent from the opinion that they wrote. You can even see, the best example is, for example, it was written, there's a concurring opinion by Justice Alito, and he lists as what would be permitted for local sign regulators to enact. He has a list, And in that list, he includes the very signs that the majority, some of the very signs that the majority opinion, Justice Thomas, found unconstitutional. So even the justices, agreeing with each other, had different views of what would be legal and illegal under the opinion they were dealing with right then. So, but my key is I don't want the city of Sebastian to be the one litigating those future cases. Those are very expensive, and they're framed in civil rights because you're dealing with the Bill of Rights, First Amendment, which means that we pay the freight. All the costs and expenses would be on the city, including the opposing attorney's fees and so forth. These are very expensive propositions. So I think that what I tried to do here was to make sure that, you know, we're not the next municipality up. So they'll go somewhere else. There are law firms that are bringing lawsuits against municipalities under the new code, under the new Supreme Court decision. And I just don't want Sebastian to be one of those. And if we've changed our code to reflect some of these things, I think we'll be okay. I think we should win. If we don't win, I will immediately come back, or even if I think that we have a serious problem with whatever issue is being raised against us, I'll come back with amendments there, rather than fight it out over 5 years and have to pay $1 million or two to litigate it. But there you are. That's the background of this proposal.
Okay.
Oh, one last thing. I think this is my first step here. I think it's a good one, but I'm not sure it's the last one. I think I may have to come back to you with another ordinance down the road. I'm not withdrawing this at all, but another ordinance, another separate ordinance that may deal with some other sections of the code. Change the wording slightly in order to better comply. But it was an interesting project, but a very difficult one. And many a night I went home and I said, I don't know how I'm going to deal with this. It's very perplexing. And I'm not alone, and the city of Sebastian isn't alone. Everybody across the country is trying to figure this out and how their code can be modified to satisfy the Supreme Court's opinion. And like I say, I'll be attending a seminar next week. This is one of the topics, so I may get some light shed there. But you have my first effort at this. And I
Okay.
thank you for being here to hear all this.
Just bear with me. I have a couple of other questions, and then we'll open it for public comment. On the section sign public,
Yes, what page are you on?
well, I have the earlier version. I labeled it page 7.
Oh.
But if you started with the front page and called that 1, it would be 8. The bottom of the page.
You're talking about the definition of public sign?
Yes, the
Okay.
definition.
That's on page 7 of what's in your kit today.
Okay, if you look at the top of page 8,
Yes.
it talks about the different types of signs, and just 4 or 5 weeks ago, we had something come up on a temporary construction sign by a utility company, and I'm just wondering, there's no reference here. Would that fit at this point, or would it fit under another area? Because this area appears to be talking about, the city signs, traffic control signs, and railroad and public transit service, those sorts of things.
The last sentence of that section says, public signs also include signs erected or installed by or on behalf of any public utility, cable, fiber optic, or wireless provider, railroad, or public transit service. So public utility signs are included here.
Okay, nothing about temporary. I was interpreting that to mean that it was a permanent sign.
No. Generally, we have a provision that says there's no signs are permitted on the public rights of way. And then we have an exception for public signs. So these signs, temporary or permanent, I think most of, well, they'll be both. There'll be both temporary and permanent signs that fit this category. For example, if a person is constructing a road for us and they need to close a lane during construction, they're going to put up signs that say 1 lane or flagman ahead or whatever. Those signs, even though they're not our signs, they're the construction company's signs, they're done on our behalf and our contracts provide for them. So we're approving them to do those safety type things in our public right-of-way. That's one example. Utility companies can too. I see Florida Power and Light out there on the right-of-way cutting trees and things like that right now, for example, and they have cones and they have barriers, tree cutting ahead or men in median or things like that. All of that is okay under this. The intent is to use public signs as an exception to the no signs on public right-of-way provision.
Not to belabor a point, but I think in what I'm referencing was not permissible, but they were attempting to do it, which was a cable company putting a under construction sign in the public right-of-way about something going on off the road in a community.
So that would be permitted under this.
It would be.
Yes. A cable is not a public utility, but that's why I listed it separately under, I said
Right.
public utility, comma, cable, comma, because that doesn't fall within the public utility umbrella. That would be permitted under this.
In the right-of-way.
Yes. In the public right-of-way.
Interesting. I have a lot to learn then. Commissioners, questions?
No.
Yeah, I'd just like to say that although this is very difficult, this is beautifully written, so well that even someone with a simple mind like me can understand it perfectly well.
Thank you for that.
I think you deserve kudos. And if you have to make some changes later on, I'm sure they will be equally as understandable. And I really subscribe to making things more simple if possible. So this is great. Thank you.
Okay, thank you.
I'll second that. Definitely. It's not a motion, but a thought. Okay, at this point, if the commissioners have no other questions, we'll open it for public comment. Anyone here present wishing to make comment on this ordinance, give us thoughts, directions? Seeing none, what I would like to do then is ask the city attorney and city staff if they have any final comments, recommendations before we proceed to consider a recommendation to council.
No, I think I've talked enough, but I'll be happy to answer any questions or discuss any issue. It's not an easy area.
Well, no questions. I believe at this point then, we'll close the public hearing. And at this point, the commissioners would have opportunity to deliberate as far as comments that we want to make or any thoughts or suggestions to put in a motion before we make the motion.
No.
I see heads shaking. I think we're fine.
Yeah.
So we're, at this point, ready for a motion then, which would be to recommend these changes be recommended to City Council by the Sebastian Plan Zoning Commission for approval. That would be next week, correct? Next Wednesday?
Yes. Is it April 10th? When are
I
they?
think the second reading is scheduled for August 10th.
August 10th. August 10th.
Okay.
I'll second that motion. Approve?
I didn't really make a
Oh,
motion.
okay,
did I?
I'm sorry. I'll second your thought, I guess.
So do we have a motion then?
I'll make the motion that this body recommend to the city council that this proposed ordinance changes be adopted.
Okay, I'll second that.
Now we're ready for a second. Okay, we have a motion and a second on the floor as presented to us this evening. Would you call the roll for a vote, please, Dory?
Mr. Kizilbosh?
Yes.
Mr. Roth?
Yes?
Ms. Cottenberg?
Yes?
Mr. Alvarez?
Yes.
Mr. Carter?
Yes.
Motion carries.
Fantastic.
Thank you, folks.
You did an excellent job, Attorney Ginsburg. Excellent.
He must have been thinking about that when he was laying in bed, right? In the hospital.
Do we have any unfinished business to discuss? Hearing none, any public input on any other items that were not on the agenda? None. Is there any new business by any of the commissioners to bring up for a future meeting? None. City attorney matters. Attorney Ginsburg?
None tonight. Thank you, sir.
Staff concerns matters for the commission?
None tonight.
We're moving right along here. And I'll ask, but I think we've covered it, items for the next agenda. None. It's appropriate, we have a motion to adjourn.
Just one question, if I may. Maybe
Yes.
staff can help with this. Up until today, the sign out front only had meetings on the east side. There was nothing on the west side. Any reason for that? Does anybody know?
Not that I know. We'll get with our, I believe our
But
builder.
but both sides were filled in today, but up until today, it wasn't.
It goes to our city clerk's office to post on that front sign there. So I'll get with Jeanette and we'll find out and let you know.
Thank you.
Okay, that's it. We are adjourned.